Being gay, specifically engaging in same-sex sexual activity, was a crime in many parts of the world during the early 1900s to the 1950s, often punishable by imprisonment, hard labor, or in some places, death. Laws generally targeted male homosexuality, often termed gross indecency or crimes against nature. Laws varied by state, but homosexual acts were illegal. The early 20th century saw increased policing, undercover stings, and raids on gay bars, as well as in public parks.
At the turn of the 20th century, legislatures made more explicit attempts to criminalize homosexuality. Several sodomy laws were expanded to include oral sex. In the 1950s, state and nationwide witch hunts of homosexual men ensued, and hate-based rhetoric equated consensual adult sex with child molestation.
In 1955, the American Law Institute voted to decriminalize consensual acts of sodomy and remove sodomy as a crime from its modern penal code. Illinois was the first state to reject its sodomy law in 1961, when the state revised its entire criminal code. Connecticut would be the second state in 1971, with 19 more states repealing their laws in the 1970s. After a 6-year battle over repealing the state's sodomy law, California passed a repeal in 1975, after a tie vote in the Senate required a vote from the lieutenant governor. In the 1980s, Pennsylvania and New York's highest courts struck down state sodomy laws, partially relying on the U.S. Constitution in their decisions. In 1986, the Supreme Court heard the case of Bowers versus Hardwick, which challenged Georgia's statute that criminalized oral and anal sex for all people, regardless of sexuality. The Supreme Court acknowledged an implicit right to privacy in the U.S. Constitution, but said that it was not enough to strike down the Georgia statute. In 1993, Nevada and the District of Columbia repealed their sodomy statutes. Arizona repealed its statute in 2001. Kentucky, Tennessee, Montana, Georgia, and Minnesota all repealed their sodomy statutes based on their state constitutions. The American Civil Liberties Union and Lambda Legal successfully brought legal challenges in several other states, including Kansas, Maryland, Arkansas, and in Texas. In 2003, the United States Supreme Court agreed to hear the case of Lawrence versus Texas. Police arrested Mr. Lawrence and Mr. Garner, and both men were later convicted of violating a Texas statute forbidding two people of the same sex from engaging in certain sexual behaviors. In a 6-3 opinion authored by Justice Anthony Kennedy, the court held that Texas's statute was unconstitutional. Their right to liberty under the Due Process Clause gives the defendants the full right to engage in their conduct without intervention of the government. The Texas statute furthers no legitimate state interest which can justify its intrusion into the personal and private life of the individual, wrote Justice Kennedy. This set a precedence in anti-sodomy laws of many other U.S. states that had this antiquated piece of legislation on their statute books were removed completely. Gay love and same-sex attraction have endured across centuries and cultures, even in the face of persistent efforts to suppress, pathologize, or criminalize them. History shows that vibrant queer subcultures and individual bonds often thrived despite attempts at suppression. Much of gay history remains hidden because historians of the past often chose not to record the lives of everyday people in same-sex relationships. One phrase that has always been at the forefront of LGBTQ+ culture is this one: